State of Wisconsin, Court of Appeals, District 2, case number 2017A-P 2288. State of Wisconsin, plaintiff, respondent versus Stephen A. Avery, defendant, appellant. Brief of the plaintiff, respondent. We will start the reading with the footnote on page 14. However, we will not be reading any of the subsequent footnotes in the response. The state has reorganized and restated the issues to clearly address the only question before this court, whether the circuit court erroneously exercised its discretion when it denied each of Avery's 5 separate motions without a hearing. Avery has presented his claims to this court as if he presented all of his arguments to the circuit court at the same time, and as if the circuit court rejected them all on the merits. This is not what happened. Avery filed his second Section 974.06 motion in June 2017, and the circuit court denied it without a hearing on October 3, 2017. Avery then filed a motion to vacate judgment on October 6, 2017, seeking to vacate the court's order so he could amend his June 2017 motion. Before the court ruled on that motion, Avery filed a motion for reconsideration and 2 supplements to it, raising a host of new arguments. The circuit court denied Avery's motion to vacate judgment and motion for reconsideration in a single order, finding no cause to vacate its judgment and finding the new claims and arguments raised in Avery's motion for reconsideration procedurally barred. Avery filed another motion on July 6, 2018, alleging a Brady violation about the state's examination of the Dassey computer, and another on March 11, 2019, alleging a Youngblood violation. These were denied without hearings on September 6, 2006, and August 8, 2019, respectively. Accordingly, whether the circuit court erroneously exercised its discretion each time when it denied the respective motion in front of it is the only question properly before this court. That question cannot be coherently addressed in the way Avery has organized his brief, with arguments that were raised in different motions and that were denied on different grounds lumped together topically. Further, to the extent that Avery has addressed his separate motions separately, he has done so non-chronologically. The state has therefore reorganized the issues. Issues presented. Number 1, did the circuit court erroneously exercise its discretion in denying Stephen A. Avery's June 2017 Wisconsin Statute 974.06 motion, which was his second Section 974.06 motion, without holding an evidentiary hearing? The circuit court concluded that Avery's motion was insufficiently pled, and that he did not show a sufficient reason for failing to raise these claims on direct appeal or in his first Section 974.06 motion. It further concluded that none of Avery's alleged newly discovered evidence raised a reasonable probability of a different result at a new trial if admitted. This court should affirm the circuit court. Number 2, was the circuit court required to allow Avery to pursue his Section 974.06 motion piecemeal for any of the following reasons? Number 1, because the parties had reached an agreement about how Avery would proceed with scientific testing. Number 2, because Avery planned to supplement his motion, but did not alert or seek approval to do so from the court. Or, number 3, because of the circuit court's 27000 preservation order. The circuit court was presented only with the first 2 of these arguments and noted that Avery never requested that the court withhold decision on his Section 974.06 motion. nor inform the court that he planned to supplement the motion until after a final ruling denying his claims. It determined that Avery could not amend a motion that was filed without reservation, quote, after he receives an adverse ruling, unquote. This court should affirm the circuit court. Number 3, did the circuit court erroneously exercise its discretion when it denied Avery's motion for reconsideration and multiple supplements to it without holding an evidentiary hearing? The circuit court noted that Avery mischaracterized as, quote, new evidence, unquote, what were really new claims, and he did not set forth a sufficient reason why these many claims could not have been raised in a single Section 974.06 motion, nor did he give a sufficient reason for filing his June 2017 motion when he knew his investigation was incomplete and that he planned on raising additional claims. It denied the claims raised in the motion and supplements as procedurally barred. This court should affirm the circuit court. Number 4, did the circuit court erroneously exercise its discretion in denying, without a hearing, Avery's motion alleging that the state violated Brady v. Maryland by failing to supply the defense with a CD containing material Detective Michael Veely copied from the Dassey hard drive, and Avery's attendant ineffective assistance of counsel claim? The circuit court found that the state turned over all of the evidence to the defense, and the defense simply failed to assign it any significance and pursue it. It further determined that Avery's ineffective assistance claim was conclusory and undeveloped. This court should affirm the circuit court. Number 5, did the circuit court erroneously exercise its discretion in denying, without a hearing, Avery's motion alleging that the state violated Wisconsin Statute 968.205 and Arizona v. Youngblood by releasing portions of the bone fragments collected in this case to the victim's family? The circuit court found that, though the state failed to abide by the notice provisions contained in the statute, it had not violated the substantive subsections, and that the material returned was neither apparently nor potentially exculpatory. Accordingly, Avery failed to allege sufficient facts showing that the state violated either the statute or his constitutional rights. This court should affirm the circuit court. Number 6, does this court lack jurisdiction to review Avery's motion to compel post-conviction discovery? The circuit court never ruled on this motion. Avery forfeited any complaints about this motion by failing to ask the circuit court to rule on it before filing his appellate brief, which this court lacks jurisdiction to review in any event because there is no written order denying it. Statement on oral argument and publication. The state does not believe that oral argument or publication are warranted. This case involves only the application of well-settled law on the procedural bar and post-conviction pleading standard to the facts, which can be adequately addressed on briefs. Introduction. Avery has embarked upon a significantly different venture than his appeal presents. He seems to erroneously believe that he is appealing the jury's determination of guilt. He further seems to believe, also erroneously, that if he can identify any conceivable alternate theory of the crime, he has, quote, disproven, unquote, the state's case against him and, quote, proven, unquote, the existence of the constitutional violations he alleged, no matter how insufficiently supported, speculative, inconsistent, far-fetched, or belatedly raised his argument is. Accordingly, the bulk of his brief is dedicated to relitigating his trial defense, though he cannot seem to settle on any particular theory. But, as he did in the circuit court, Avery has all but ignored the actual issue at the heart of this appeal, the procedural posture of his case. This case is before this court on appeal of the circuit court's orders denying, without hearings, Avery's second through sixth motions, attempting to collaterally attack his conviction. These motions were denied without hearings on the grounds that they were procedurally barred, insufficiently pled, or that the record conclusively demonstrated Avery was due no relief. Accordingly, the question on appeal is not whether Avery is guilty of killing Teresa Halbach. That question was for the jury, which many years ago answered yes, beyond a reasonable doubt. Nor is the question on appeal whether Avery's latest counsel can construct a different trial defense, find new ways to attack the trial evidence, or identify issues that have not been raised previously. The only question before this court in this appeal is whether any of Avery's motions entitled him to an evidentiary hearing. The answer to that question is no. Though Avery made a litany of allegations across his many motions, three critical things were absent from his forests of paper: sufficient reasons for failing to raise all his post-conviction claims at the same time, sufficient material facts of record to support his allegations, and any developed argument applying the law to explain why the facts of record led to the legal conclusions Avery claimed. It is too well settled for argument that a circuit court has discretion to deny insufficient motions such as Avery's without a hearing. Avery has now glossed over his piecemeal litigation and the deficiencies in his motions by simply re-arguing the merits of his claims in his appellate brief, without any reference to how or when he presented them to the circuit court. But on review of a circuit court's decision to deny a post-conviction motion without a hearing, this court looks only to the sufficiency of allegations contained in the four corners of the motion filed in the circuit court. And Avery has fallen far short of showing that any of his motions were sufficient to entitle him to a hearing. Indeed, he has almost entirely failed to address the issue, despite it being his burden and the only issue on appeal. The circuit court appropriately exercised its discretion in denying each of Avery's motions without a hearing, and Avery has failed to show otherwise. This court should affirm the circuit court. Statement of facts. Pursuant to Wisconsin Statute Rule 809.19, as respondent, the state opts to omit a statement of the facts. Pertinent facts will be provided in the argument section. Fundamental principles of post-conviction review. A. Criminal defendants are required to raise all post-conviction claims at the same time, absent a sufficient reason for failing to do so. Quote, "We need finality in our litigation," unquote. State versus Escalona Naranjo. Accordingly, after the time for a direct appeal has passed, a defendant's ability to attack a conviction or sentence is limited. Jurisdictional or constitutional challenges to a conviction or sentence may be brought pursuant to Wisconsin Statute 974.061, but Wisconsin Statute 974.064 bars successive post-conviction litigation absent a, quote, "sufficient reason," unquote, for not raising any issue advanced in a later post-conviction motion on direct appeal or in an earlier motion. State v. Lowe, quote, "successive and often reformulated claims clog the court system and waste judicial resources," unquote. State ex rel. Maceman v. Christie, thus, quote, the statutorily mandated review process, unquote, under 974.064 requires that all of a defendant's claims for post-conviction relief may be, quote, consolidated into one motion or appeal, unquote. In other words, convicted defendants are not entitled to pursue an endless succession of post-conviction remedies. Quote, successive motions and appeals, which all could have been brought at the same time, run counter to the design and purpose of the legislation, unquote. Escalona Naranjo. B. Subsection B. To warrant a hearing, motions must contain sufficient material facts that would warrant relief, if true, and the record cannot conclusively demonstrate otherwise. Quote, to move beyond the initial prerequisites of Wisconsin Statute 974.064 and Escalona Naranjo, and to adequately raise a claim for relief, a defendant must allege sufficient material facts. For example, who, what, where, when, why, and how. That, if true, would entitle the defendant to the relief he seeks. State versus Romero Georgiana, citing State versus John Allen. Conclusory statements that do not contain these key facts are insufficient to entitle the defendant to a hearing. John Allen. The sufficiency of the allegations in the motion, however, is not the end of the inquiry. Quote, a circuit court has the discretion to deny a defendant's motion, even a properly pled motion, without holding an evidentiary hearing, if the record conclusively demonstrates that the defendant is not entitled to relief, unquote. State v. Sola. C. Standard of review. Quote, this court will uphold the circuit court's findings of fact unless they are clearly erroneous, unquote. State v. Seal. A circuit court's factual findings are clearly erroneous only if they have no support in the record. Shriver v. Physicians Insurance Company of Wisconsin. Whether claims are barred by Wisconsin Statute 974.064 and Escalona Naranjo is a question of law this court reviews de novo. State v. Toll-free. Likewise, whether a defendant's post-conviction on its face alleges facts which would entitle the defendant to relief, and whether the record conclusively demonstrates that the defendant is entitled to no relief, are questions of law that an appellate court reviews de novo. Sola. Citation omitted. This court reviews only the, quote, only the allegations contained in the four corners of the defendant's motion, and not any additional allegations that are contained in the defendant's brief. John Allen. If the defendant's motion fails to adequately allege a sufficient reason to overcome Escalona Naranjo, does not contain the requisite material facts, quote, presents only conclusory allegations, or if the record conclusively demonstrates that the defendant is not entitled to relief, unquote. Then this court reviews the circuit court's decision to grant or deny a hearing, quote, under the deferential erroneous exercise of discretion standard, unquote. A court exercises discretion when it considers the facts of record and reasons its way to rationale, to a rational, legally sound conclusion, unquote. State v. Jeske. Quote, the court's discretionary determinations are not tested by some subjective standard or even by this court's own sense of what might be a right or wrong decision in the case, but rather will stand unless it can be said that no reasonable judge acting on the same facts and underlying law could reach the same conclusion, unquote. Additionally, quote, it is well established that if a trial court reaches the proper result for the wrong reason, it will be affirmed, unquote. State v. Holt. Argument 1. Roman numeral 1. The Circuit Court properly denied Avery's June 7, 2017 motion without holding an evidentiary hearing. Allegations in Avery's June 2017 motion. As relevant here, Avery raised the following claims in his June 27, 2017 Section 974.06 motion. Number 1. Avery's trial attorneys, Dean Strang and Jerome Buting, were ineffective for failing to obtain 6 additional expert witnesses in blood spatter patterns, trace evidence examination, forensic anthropology, buried remains, DNA testing, and, quote, police procedure, unquote. Number 2, trial counsels were ineffective for failing to conduct various, quote, experiments, unquote. Number 3, that, quote, only one person, unquote, Ryan Hilgus, quote, meets the requirements of Denny as a third-party suspect, unquote. Number 4, trial defense counsel failed to properly investigate a variety of topics, unquote, about several evidentiary items. Number 5, the state withheld, in violation of Brady v. Maryland, a CD of a voicemail Teresa Halbach left on the Zipper family's answering machine the day of her, stating that Ms. Halbach was having trouble finding their house. Number 2, quote, unedited flyover video, unquote, from an air search of the Avery property. And number 3, investigators' purported, quote, knowledge, unquote, that Teresa Halbach's Toyota RAV4 was driven onto Joshua Verdon's property because Verdon provided an affidavit stating that some unknown person from the Department of Justice told him that they, quote, believed, unquote, the RAV4 was driven onto the Avery property. Number 6, that Avery had newly discovered evidence establishing that, one of the damaged bullets introduced at trial, item FL, was not shot through the victim's skull. Number 2, Avery's DNA on the RAV4's hood latch was planted. And number 3, Avery's DNA on the key to the RAV4 was planted. Avery alleged that his sufficient reason for failing to raise these claims on direct appeal was ineffective assistance of post-conviction counsel. Avery further alleged that his sufficient reason for failing to raise all of these claims in his 2013 pro se motion, pro se section 974.06 motion, was that he, quote, had no way of knowing, unquote, about his claims, but because he was a, quote, learning disabled indigent prisoner, unquote. The Circuit Court's order denying the motion. On October 3, 2017, the Circuit Court denied the motion without an evidentiary hearing. The court determined Avery had not shown a sufficient reason why these issues could not have been raised in his 2013 motion or other prior post-conviction litigation. It further found that Avery's arguments stemming from his new experts' reports omitted, quote, several significant facts, unquote, showing that the results of the testing did not show what Avery claimed they did, and that he relied mainly on, quote, conclusory allegations, unquote. Accordingly, it found Avery had not met his burden to show that there was a reasonable probability of a different result at a new trial where these results were admitted. A. Avery failed to show a sufficient reason for failing to raise his June 2017 claims in his February 2013 motion or on direct appeal, so they are procedurally barred. Avery's June 2017 Wisconsin Statute 974.06 motion was his third attempt at post-conviction relief. For the court to reach the merits of his allegation, then Avery had to overcome Escalona Naranjo twice. He had to adequately plead a sufficient reason for failing to raise his June 2017 claims in his Wisconsin Statute 974.02 motion and his 2013 Section 974.06 motion. See, for example, Romero-Georgiana. Avery showed neither, so the Circuit Court properly exercised its discretion in denying his motion without a hearing. Number one, Avery's conclusory allegation that he did not raise this claim in his 2013 motion because he is indigent and has no legal training was not a sufficient reason. Avery failed to properly plead a sufficient reason for not raising his 2017 claims in his 2013 motion, and therefore this court needs go no further to determine that the Circuit Court properly denied his June 2017 motion without a hearing. Avery devoted a mere 2 paragraphs of his 200-plus page motion to alleging a reason for failing to raise his claims in his 2013 motion. The sole reason Avery offered was a conclusory statement that he had, quote, lack of legal knowledge, unquote, and unspecified, quote, cognitive deficiencies, unquote, and claimed he therefore, quote, had no way of knowing the factual and legal basis of the claims set forth herein. As a learning disabled indigent prisoner, Mr. Avery simply could not have known them, unquote. The only facts he supplied about this claim were that his current attorney has spent a lot of time and money preparing the motion. Avery's allegation was factually and legally insufficient. First, assuming that cognitive difficulties and a lack of factual and legal knowledge could have been sufficient reason, Avery failed to allege sufficient material facts to support his assertion. See State v. Aaron Allen. To be, quote, sufficient, unquote, defendant's reason for failing to raise claims previously must be supported by more than conclusory allegations. Avery claimed that, quote, numerous unique circumstances are present here that provide sufficient reasons the current claims were not previously presented, unquote. But he did not attempt to explain what those circumstances are. He did not explain why the circumstances are unique, why or how they precluded Avery from knowing about his claims, what legal or factual knowledge was required that Avery lacked, particularly in light of his many pro se filings setting forth relevant law and discussing his case, what Avery's, quote, cognitive deficiencies, unquote, are, or how they prevented him from knowing about and raising his claims, or why current counsel's decision to spend vast sums of money meant that Avery was unaware of his claims previously. Avery's claim that he had no way to know the, quote, factual basis, unquote, for his claims was particularly insufficient. It amounted to a bare passing mention of the term, quote, factual basis, unquote. In other words, Avery provided no, quote, facts that allowed the reviewing court to meaningfully assess, unquote, his reason. State v. Bentley. See also State v. I. Saunders. The Circuit Court was well within its discretionary authority to deny the motion without a hearing for failing to overcome the procedural bar. Avery's allegation was insufficient for a second reason. While a lack of knowledge of the factual basis for a claim may be a sufficient reason, it has long been recognized that a defendant's pro se status or lack of legal knowledge is not. See State v. Jensen. ignorance of the law is no defense, unquote. See also Jackson v. Bainon. Quote, no Wisconsin court has recognized ignorance of the law as a sufficient reason under 974.064, unquote, and collecting cases. Nearly all collateral attacks are raised by pro se prisoners, many of whom have intellectual challenges and very few of whom are lawyers. While the Wisconsin courts liberally construe pro se prisoners' filings, prisoners are still expected to properly raise claims for relief, including sufficiently overcoming the procedural bar. Romero, Georgiana. None of the cases Avery cited support his claim that lack of legal knowledge, indigency, or pro se status is a sufficient reason. Avery misrepresented or misread them all. In Aaron Allen, the court rejected the defendant's claim that his unawareness of the factual basis for his claims was a sufficient reason, because the court records show that the claims, quote, involved events in which Allen was personally involved and had personal knowledge, unquote. Aaron Allen. That has nothing to do with the defendant's, quote, unawareness of the legal basis of his claim, unquote. And Aaron Allen establishes that lack of knowledge of the, quote, factual basis, unquote, for a claim does not mean what Avery appears to think it means. Lack of knowledge of the factual basis for a claim means an event occurred that supported a claim and the defendant had no way of knowing about the event. See Aaron Allen. It does not mean that the defendant simply did not know what facts an attorney might use to argue the claim. Avery knew all about the facts of his case. Also in Aaron Allen, the court rejected Avery's precise argument that State v. Howard established lack of legal sophistication as a sufficient reason. Aaron Allen established that lack of knowledge of the legal basis of the claim may be a sufficient reason, quote, where a subsequent Supreme Court decision constituted a new rule of constitutional law, unquote. Like in Allen, Howard is inapposite here. There, quote, there is no question that Strickland v. Washington, unquote, and Brady were, quote, established law at the time, unquote. Avery filed his 2013 Section 974.06 motion. Aaron Allen, State ex rel. Kyles v. Pollard, does not stand for the proposition that lack of legal knowledge due to pro se status is a sufficient reason either. In Kyles, the defendant was denied counsel during a critical stage of the proceeding. The Supreme Court determined that his Knight petition was not procedurally barred by his previous attempts to reinstate his direct appeal. But that was because the court found it, quote, incongruous to the state that a defendant was denied the right to counsel and then preclude the defendant from raising a claim because of errors made due to the absence of counsel, unquote. There is no right to counsel on collateral attack. Warren v. Schwartz. So, Avery cannot plausibly argue that Kyles established that pro se status is a sufficient reason for failing to raise a claim in an earlier 974.06 motion where he had no right to counsel. Neither this court nor the Wisconsin Supreme Court has ever construed Kyles in the manner Avery suggests. Number 2, Avery has not shown that his motion was sufficiently pled. Avery has failed to show that his June 2017 motions, 2 conclusory paragraphs about his 2013 pro se motion, were sufficiently pled, or that the record does not conclusively refute them. Avery's claims in his brief that he, quote, has met all of the Allen requirements, unquote, for his claims, but he has misunderstood the pleading standard, Avery directs this court only to where he purportedly met those requirements in his appellate brief. To be entitled to a hearing, Avery had to meet those requirements in his motion to the circuit court. He cannot cure the deficiencies in his motion in his appellate brief. John Allen. Avery claims that the circuit court, quote, did not analyze whether these collective circumstances constituted a sufficient reason, unquote. But he's made no showing that he pled sufficient facts for the court to analyze. The court noted that Avery claimed that his pro se motion, quote, should not preclude his June 2017 motion from being heard, unquote. But the court found, quote, there is no argument or showing of a sufficient reason why these issues could not have been raised in prior, unquote. Avery simply stating he was incapable of raising the claims is not a factually supported argument explaining why not, and the circuit court was not required to develop it for him. Furthermore, Avery's assertion that he was incapable of recognizing and raising legal claims was demonstrably false. The circuit court remarked that Avery's pro se motion, quote, recognized significant legal issues which the court previously ruled on, unquote. Those issues included ineffective assistance of trial and post-conviction counsel. The fact that the court rejected those claims does not mean that Avery was incapable of raising legal claims, as Avery appears to believe. Avery now attempts to bolster his motion by asserting that his reason is sufficient because he, quote, wrote to dozens of attorneys, unquote, and, quote, wrote to laboratories that would not respond unless he had an attorney, unquote. Avery did not make these assertions in his June 2017 motion, and therefore they are irrelevant to evaluating whether the circuit court properly denied the motion it had before it. Regardless, these allegations refute Avery's assertion. Obviously, if Avery contacted attorneys and laboratories in an attempt to raise these issues, he knew that they were available to be raised. Otherwise, Avery simply reiterates that he told the circuit court that he lacked the legal sophistication to raise the claims, quotes his own Section 974.06 motion as legal authority, and directs this court to the same inapposite case law he cited below. None of that shows that he sufficiently pled his motion. In short, Avery's bare-bones assertion in his June 2017 motion was not enough to allow the circuit court to meaningfully evaluate his alleged reason for failing to raise his June 2017 claims in his 2013 motion. So the court found that he had not shown a sufficient reason. That was a reasonable evaluation of Avery's motion, and he has failed to show otherwise. The circuit court properly exercised its discretion in denying Avery's June 2017 motion without a hearing. Number 3, Avery's allegation that post-conviction counsels were ineffective was insufficiently pled and meritless. Even if this court overlooks Avery's failure to show a sufficient reason for failing to raise his current claims in his 2013 motion, it should still affirm the circuit court. Avery failed to sufficiently show that either trial or post-conviction counsel were ineffective. Although the circuit court was wrong about the law on post-conviction procedure, the record shows that it still reached the right conclusion, and accordingly, this court must affirm its decision to deny this motion without a hearing. A. Law governing ineffective assistance of counsel. Quote, Wisconsin criminal defendants are guaranteed the right to the effective assistance of counsel through the 6th and 14th Amendments to the Federal Constitution and Article 1, Section 7 of the Wisconsin Constitution, State v. Domke. Ineffective assistance claims are evaluated using the two-pronged test set forth in Strickland v. Washington. To prevail under Strickland, a defendant must prove that his counsel's performance was both deficient and prejudicial. Strickland. Quote, the defendant does not show the first element simply by demonstrating that his counsel was imperfect or less than ideal. Unquote. State versus Balliet. Rather, quote, to prove deficient performance, a defendant must show specific acts or omissions of counsel that are outside the wide range of professionally competent assistance. Unquote. State v. Arredondo. Counsel's decisions based on reasonably sound strategy are, quote, virtually unchallengeable, unquote, and do not constitute deficient performance. Strickland. Quote, the defendant may not presume the second element, prejudice to the defense, simply because certain decisions or actions of counsel were made in error. Balliet. To prove prejudice, quote, the defendant must show that counsel's deficient performance actually had an adverse effect on the defense. Unquote. Strickland. Further, the defendant must do more than, quote, show that his counsel's errors had some conceivable effect on the outcome of the proceeding. Unquote. Domke. The defendant must show that, quote, there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. Unquote. Romero, Georgiana. B. Avery did not show that post-conviction counsels were ineffective. Subsection 1. Law governing ineffective assistance of post-conviction counsel as a sufficient reason. Avery claimed that his sufficient reason for failing to raise on direct appeal his ineffective assistance of trial counsel claims regarding hiring experts, performing experiments, and attempting to pin the crime on Ryan Hilgas, along with his Brady claims regarding the zipper voicemail, the flyover video, and Redon's allegations, was that his post-conviction counsel, Suzanne Hagapian and Martha Askins, were ineffective. Ineffective assistance of post-conviction counsel may constitute a sufficient reason for failing to include claims in earlier motions. Romero, Georgiana. To overcome the procedural bar on that ground, though, the defendant must allege sufficient facts that are supported by the record and would show that post-conviction counsel's failure to raise the claim was both deficient and prejudicial. If the defendant makes, quote, a mere conclusory allegation that his post-conviction counsel was ineffective, his reason is not sufficient, unquote. Additionally, quote, a defendant who alleges in a 974.06 motion that his post-conviction counsel was ineffective for failing to bring certain viable claims must demonstrate the claims he wishes to bring are clearly stronger than the claims post-conviction counsel actually brought, unquote. Quote, this standard is difficult to meet because the comparative strength of two claims is usually debatable, unquote. Shaw v. Wilson. Subsection 2. Avery's allegations about post-conviction counsel were conclusory and meritless. The state does not dispute that the circuit court confused the procedure for raising ineffective assistance of post-conviction counsel with the procedure for raising ineffective assistance of appellate counsel when rejecting this claim. However, whether a Section 974.06 motion adequately pleads a sufficient reason for failing to bring available claims is a question of law reviewed de novo. Romero, Georgiana. And this court will affirm if the circuit court reached the right result for the wrong reason. Holt. And here, the record shows that the circuit court still properly denied Avery's motion. Avery's motion, quote, was conclusory because it failed to carefully address the two elements of ineffective assistance for post-conviction counsel set out in Strickland, and the motion generally ignored the 5 W's and the 1 H methodology outlined in John Allen, unquote, Valiette. Hagopian and Askins raised 4 issues on Avery's direct appeal. Number 1, the court had improperly barred Avery from admitting third-party perpetrator evidence. Number 2, multiple searches had violated Avery's Fourth Amendment rights. Number 3, the trial court had improperly excused a deliberating juror. And number 4, trial counsels were ineffective for acquiescing to the dismissal. Avery stated that post-conviction counsels were ineffective, quote, because they failed to argue that Mr. Avery's trial defense counsel was ineffective as described, unquote, in his June 2017 motion. He then claimed that, quote, ineffective assistance of trial counsel clearly stronger than the issues raised in their 974.02 motion, unquote. Avery recited how the post-conviction court ruled on the third-party perpetrator claim and reiterated his alternate theory of events constructed with his new experts and, quote, experiments, unquote. He then stated that Hagopian and Askins, quote, should have, unquote, raised these ineffective assistance and Brady claims, quote, should have, unquote, learned this alternate theory of events from Avery and declared post-conviction counsel ineffective. Though Avery cited 2 cases about ineffective assistance in his June 2017 motion, he failed to apply that law to the facts and explain how or why Hagopian's and Askins' failure to raise his new claims was objectively unreasonable, and that there was reasonable probability of a different result if they had. His motion was insufficient on multiple fronts, and accordingly, Avery failed to overcome the procedural bar. I. Avery's claims about the Zipper CD, Redon's alleged conversation, and the flyover video was insufficiently pled. Avery's bald allegation that Hagopian and Askins, quote, should have, unquote, raised the Brady claims is facially insufficient because it simply concludes that failure to do so was deficient and prejudicial without providing any facts or developing any argument. John Allen, Romero, Georgiana. Avery made no attempt to show why it was unreasonable not to raise these claims, provided no evaluation of the comparative strength of these claims to the claims post-conviction counsels raised, and made no attempt to show that there was a reasonable probability of a different result. The underlying claims were insufficiently pled as well. Avery's allegation that Redon supposedly spoke with some unidentified DOJ personnel fails to provide any material facts about this claim. Avery does not say who Redon had this conversation with, when it occurred, what the context was, what this person's, quote, belief, unquote, was based on, or why Redon did not tell trial counsel or anyone else about it in the 12 years between trial and his affidavit. Further, Avery did not provide any facts to establish that it would be material. He said only that, quote, this information could have been used to impeach the state's witnesses, unquote, with nothing about who it would have impeached or why that would raise a reasonable probability of a different result, considering the rest of the evidence. Avery further claimed Redon's testimony would have provided exculpatory evidence that the RAV4 was planted on his property, unquote. But Avery failed to plead any facts establishing this, either because he alleged no facts about when this conversation took place, who said it, and why, when, or from where they believe the RAV4 was driven onto the Avery's property. An unidentified DOJ employee purportedly saying they, quote, believed, unquote, the RAV4 was driven onto the Avery property at some unidentified time fails to establish that it was driven onto the property after the murder or by someone other than Avery. Avery has made no attempt on appeal to show that his motion was sufficiently pled on this claim, either as a standalone claim or on his allegation that post-conviction counsels were ineffective, and simply re-argues the Brady claim. But again, the merits of this claim are not before this court. The issue is whether Avery sufficiently pled that Hagapian and Askins were ineffective for failing to raise it. By failing to address the issue on appeal, Avery has failed to meet his burden. Similarly, Avery's claim that the flyover video was edited was utterly devoid of facts and relied wholly on Avery's speculation that more footage must have existed because the prosecutor said the RAV4 was not visible on the video, and the flyover produced only 3 minutes of footage. And Avery has again failed to show that his motion was sufficiently pled, either as a claim against post-conviction counsel or on his Brady claim, and simply re-argued the Brady claim, but still provided nothing more than his unsupported speculation that the video was edited. He then asked this court to authorize an impermissible fishing expedition, stating that, quote, an evidentiary hearing is necessary to determine the credibility of the state's claim that only 3 minutes of flyover footage exists, unquote. An evidentiary hearing is a forum to prove factually supported claims, not a fishing expedition to discover them. Balliet. Post-conviction counsels were not ineffective for failing to raise a claim based on nothing. Avery's Brady claim about the message the victim left on the zipper's answering machine was insufficiently pled. 2, because Avery failed to establish that the message was suppressed, exculpatory, or material. Avery did not provide anything from Strang or Buting showing this was not turned over to the defense, and simply declared it wasn't because the state can't locate it now. That shows nothing. Avery then mused that the 2:12 p.m. voicemail Teresa Halbach left on the zipper's answering machine about having trouble finding their house must have been exculpatory because the prosecution failed to play it for the jury. That is nothing more than speculation. Besides, Joellen Zipper testified at trial and said Teresa Halbach was at their house, quote, around 3 o'clock, unquote, and that Joellen heard the message later that evening, but had missed the call because she was outside. Nothing about Halbach leaving a voicemail at 2:12 p.m., stating that she can't find the Zipper's house, but then later arriving does anything to, quote, contradict the timeline established by the state, unquote. And Avery still provides only speculation about his claim. He again just says the voicemail, quote, may have contradicted the timeline established by the state, unquote, that Ms. Halbach's last stop was Avery's. He fails to explain how, though. The claim was, and is, insufficiently pled. Aye. Avery's claims about ineffective assistance of trial counsel were insufficiently pled and conclusively refuted by the record. That leaves Avery's claim that Hagapian and Askins were ineffective for failing to claim Strang and Buting were ineffective for failing to pursue and present the retooled, quote, planted evidence, quote, defense he created in his June 2017 motion, alleging that, quote, the killer, unquote, planted the blood evidence and the victim's remains and effects, and relying on a multitude of experts to conduct experiments about the trial evidence. In a nutshell, Avery argued in his June 2017 motion that Strang and Buting were ineffective because Avery believes he could have prevailed at trial if Strang and Buting had presented his, quote, planted evidence, unquote, defense in the manner current post-conviction counsel formulated. Therefore, he concluded, Hagapian and Askins must also have been ineffective for failing to allege that Strang and Buting were ineffective on that ground. That is a fundamental misunderstanding of what is required to show ineffective assistance of counsel, trial, or post-conviction. Avery simply alleging that Strang and Buting could have presented a, quote, planted evidence, unquote, defense differently by hiring experts, performing experiments of dubious reliability, and claiming that the blood evidence was planted, quote, by, quote, the killer, unquote, and not law enforcement, does not provide anything that would establish Strang and Buting were ineffective, even if the facts Avery alleged. See, for example, State versus Breetzman. Quote, an accused cannot follow one course of strategy at the time of trial, and if that turns out to be unsatisfactory, complain he should be discharged or have a new trial, unquote. Lee versus State. Quote, to permit post-conviction counsel to argue for a different game plan after the contest is over would be a Monday morning quarterbacking. After all, there are, quote, countless ways to provide effective assistance in any case given. Strickland. And counsel, quote, counsel is entitled to formulate a strategy that was reasonable at the time and to balance limited resources in accord with effective trial tactics and strategies, unquote. Harrington v. Richter. Neither a disappointed defendant nor a court may, quote, second guess counsel's performance solely because the defense proved unsuccessful, unquote. Valiette. Second guessing supported by speculation is all Avery provided, though either in his motion or his brief, Avery has simply taken the trial record and, working backwards, quote, stressed what current post-conviction counsel would have done differently had she conducted the defense at the time of trial, unquote. Weatherall v. State. But it has long been settled that it, quote, it is the considered judgment of trial counsel that makes the selection among available defenses, not the retroactive conclusion of post-conviction counsel, unquote. Weatherall. And that a court must not evaluate counsel's performance based on hindsight, like Avery has done here. Strickland. Rather, to show deficient performance, a defendant must show that counsel's acts or omissions were objectively unreasonable from counsel's perspective at the time. That is, counsel's decisions were outside the boundaries, quote, of reasonable professional judgment, unquote, under the circumstances. Strickland. So, Avery had to show that, from Strang and Buting's perspective before trial and balancing limited resources, it was objectively unreasonable for Strang and Buting not to consult and present this bevy of experts and, quote, experiments, unquote, not to construct this alternate theory of events, alleging that Ryan Hilges abducted and killed the victim and then planted the red for the blood evidence and the victim's remains and personal effects to frame Avery, and not to present that defense instead of the one they chose, Richter. He also had to show there was a reasonable probability that jury would have acquitted him if they did these things. And despite Avery's laundry list of Strang and Buting's alleged failures, Avery alleged no material facts of record that would establish that Strickland required them to do any of this, or that Avery was prejudiced by these alleged failures. His ineffective assistance of trial counsel claims were insufficiently pled, So his ineffective assistance of post-conviction counsel claim was as well. State v. Zebart. To establish that post-conviction or appellate counsel was ineffective, a defendant bears the burden of proving that trial counsel's performance was deficient and prejudicial, unquote, as well. A. Several of Avery's claims about trial counsel are misframed, inappropriately raised, or not argued in his brief. Several of Avery's claims in his brief on this point do not warrant discussion because they are misframed, insufficiently developed, or forfeited by his failure to raise them in the trial court. Avery's single sentence that he, quote, described in his June 2017 motion a variety of failures of trial defense counsel to conduct a significant investigation before trial, unquote, is devoid of any facts or argument that the circuit court erroneously exercised its discretion or even any explanation what, quote, failures, unquote, he is discussing. Similarly, Avery never mentions hiring a, quote, police procedure, unquote, or, quote, forensic pathology, unquote, expert in his appellate brief until his summary sentence on this point. Though he references experts in these later subjects later in his brief, he provides no developed argument about why Strang and Buting were ineffective for failing to hire them. Further, no Wisconsin case has ever found that a, quote, police procedure, unquote, expert is admissible. Given the high likelihood of such testimony devolving into a mini-trial about the propriety and protocols of the police department, a, quote, police procedure expert, unquote, would be excluded under Wisconsin statute 904.03 for causing confusion of the issues, undue delay, and waste of time. Quote, it is insufficient to just state an issue on appeal without providing support for the position and providing legal authority supporting the position, unquote. And issues raised in the trial court but not argued on appeal are deemed abandoned. A.O. Smith Corp. Versus Allstate Insurance Companies. Avery's conclusory allegations on these claims are insufficient to warrant consideration. Indeed, they are insufficient to even allow the state to formulate a response. State v. Pettit. Washara County v. Graff. Avery did not provide any argument on these points, and the state is not required to develop them for him in order to refute them. See State v. Jackson. Those claims are abandoned. Furthermore, it is, quote, a fundamental appellate precept, unquote, that this court, quote, will not blindside trial courts with reversals based on theories which did not originate in their forum, unquote. Schoncheck versus Picard, Inc. Accordingly, quote, arguments that are raised for the first time on appeal by an appellant are deemed forfeited, unquote. In regards to commitment of Bollig. Several of Avery's appellate arguments about these experts are forfeited. In Avery's June 2017 motion, he claimed that Dr. Christopher Palanik's examination of bullet fragment item FL and ballistics expert Lucien Hogg's conclusions about item FL were newly discussed. Avery never alleged that Strang and Buting were ineffective for failing to hire Hogg or for failing to have Palanik conduct a trace evidence examination of item FL, as he now claims. Avery's claims that he hired a, quote, audio expert, unquote, also appeared nowhere in his motions to the trial court and is insufficiently developed to warrant discussion. In Avery's motion, he simply declared what the audio clip supposedly said in a single sentence. Avery failed to even identify who the supposed, quote, audio expert, unquote, is, or what, quote, enhancement, unquote, they allegedly did, let alone argue anything related to sufficiency of his motion or to the two prongs of Strickland on this point. Avery cannot show that the circuit court erroneously exercised its discretion by presenting arguments on appeal that he did not present to the circuit court. These claims are forfeited. Binder v. City of Madison. Issues not raised in the trial court will not be considered for the first time on appeal. Later in Avery's brief, he claims that Strang and Buting, quote, could have hired a forensic pathologist, unquote, Dr. Larry Bloom, to opine that the scratches on Bobby Dassey's back are inconsistent with the dog's paw. But this claim was never raised in the circuit court, and certainly not in Avery's June 2017 motion. Avery simply offered Bloom's opinion in his July 6, 2018 motion. Even if that were construed as an ineffective assistance claim, the circuit court denied Avery's ineffective assistance claims raised in that motion as insufficiently pled, which is supported by the record. Avery's ineffective assistance claim in that motion was a final catch-all paragraph stating that if the court rejected his Brady claims, it should find counsel ineffective, without developing any argument on the issue. There is no question the circuit court properly denied that allegation without a hearing. Additionally, all of Avery's claims that Strang and Buting were ineffective for their, quote, failure to investigate and impeach, unquote, Bobby Dassey, were not raised until Avery's October 23 motion for reconsideration. The circuit court denied the claims in Avery's motion for reconsideration as procedurally barred because Avery did not offer a sufficient reason for failing to raise these arguments in his June 2017 motion. Avery has inappropriately re-argued those claims here in an effort to overleap the procedural bar without making any argument that he showed a sufficient reason for failing to raise these claims in his June 2017 motion. This court should decline to address these claims. The state will address whether Avery's motion for reconsideration was sufficiently pled in Section 3 of this brief. B. Avery's remaining ineffective assistance of trial counsel claims did not warrant a hearing. The ineffective assistance claims Avery both actually raised in his 2017 motion and has provided some argument about in his appellate brief, did not warrant a hearing. Avery claims Strang and Buting were ineffective for failing to hire blood spatter expert Stuart James, trace evidence expert Christopher Polanek, to determine whether the RAV4 key found in Avery's house was a sub-key, quote, DNA expert Carl Reich, to test how much DNA a person leaves on a hood latch by touch, and forensic anthropologist Stephen Symes. He further claims Strang and Buting were ineffective for failing to conduct various experiments themselves, failing to, quote, discover, unquote, that Avery's blood in the RAV4 did not come from the vial of his blood located in the Manitowoc County Clerk of Circuit Court's office, failing to, quote, investigate, unquote, Avery's claim that his blood from his bleeding finger was removed from the sink by the, quote, real, unquote, killer, who then planted the blood evidence in the RAV4, and failing to, quote, establish, quote, unquote, Ryan Hilgis as a Denny suspect. Avery did not provide sufficient material facts in his motion that would show counsels were ineffective for failing to do any of these things. Counsels were not ineffective for failing to hire more experts and perform experiments. Quote, Strickland does not enact Newton's third law for the presentation of evidence, requiring requiring for every prosecution expert an equal and opposite expert, the defense, unquote. Richter, quote, in many instances, cross-examination will be sufficient to expose defects in the expert's presentation. When defense counsel does not have a solid case, the best strategy can be to say that there is too much doubt about the state's theory for a jury to convict, unquote. And here, Avery did not show that Strickland required Strang and Buting to call these experts or perform these, quote, experiments, unquote, or that there was a reasonable probability of a different result if they had. Cross-examination and the experts they did call effectively established Avery's defense, and Avery's new experiments proved nothing. As a preliminary matter, unlike Avery's other ineffective assistance claims, the circuit court addressed the merits of Avery's claims that Strang and Buting were ineffective for failing to present Reich's experiments about the quantity of DNA left on the hood latch, and Palanik's conclusions about the key being a subkey. The circuit court discussed them in the portion of its order, concluding that there was not a reasonable probability of a different result at trial if Avery's DNA testing-related experiments were admitted. To avoid duplication and clearly address the reasons the court gave for denying Avery's motion, the state addresses these arguments in section IB. That leaves Avery's claims that Strang and Buting were ineffective for failing to hire blood spatter expert Stuart James, forensic anthropologist Stephen Symes, and for failing to conduct various, quote, experiments themselves. First, Avery has again failed to argue on appeal that his motion was sufficiently pled to warrant a hearing on these claims and merely re-argues their merits. Because Avery has failed to address the issue on appeal, he has failed to meet his burden. State versus Scholar. Nevertheless, nothing he alleged in his motion met the pleading standard anyway, either because Avery's allegations were conclusory or because the record conclusively demonstrated that he was due no relief, or both. Avery's blood spatter expert, James, far from, quote, demonstrated that Mr. Avery's blood was planted in Ms. Halbach's Rob 4, unquote. For this proposition, Avery relied on an experiment conducted by James in which blood was dripped from James's middle finger, and he left blood in a test Rab 4 in several more places than where Avery's blood was found in Ms. Halbach's Rab 4. Avery then concluded that he proved the blood in Ms. Halbach's Rab 4 was planted by being, quote, selectively dripped, unquote, and, quote, applied with an applicator, unquote, because James was able to construct similar blood stains to those in Ms. Halbach's Rab 4 by that method. Avery further asserted that he proved that the blood flakes found on Ms. Halbach's Rab 4 were scraped off of Avery's sink and planted because when James dripped blood on the floor of the Rab 4, it soaked into the carpet, and James was able to create blood flakes by scraping dried blood off a sink with a scalpel. None of that proves anything. James being able to recreate something by a particular method doesn't show that no other method was possible. And James never opines that, quote, the most likely source, unquote, of the blood in the Rab 4 was the blood in Avery's sink, unquote, as Avery claims. James' affidavit says only that the blood in the Rab 4 is, quote, consistent with an explanation other than, unquote, Avery's being in the Rab 4 with an actively bleeding finger, and that James would expect an actively bleeding finger to leave blood in other places. But James, quote, experiments, unquote, simply assume a number of variables James cannot account for, such as how deep Avery's reopened cut was, how much partially healed cut would have bled, how he moved about the robbed floor, and the many other ways blood flakes could end up somewhere. James' next experiment purportedly, quote, proving, unquote, that the blood spatter on the rear cargo door was caused by Miss Halbach being, quote, struck with an object such as a hammer, unquote, with the cargo door open rather than being thrown into the cargo area is irrelevant even if true. The point was that Miss Halbach's blood was in the cargo area, showing that she was at some point bleeding there, not the exact method of how the blood got there. And nothing in Avery's motion or the exhibits he cited supports his conclusion that those bloodstains occurred as the result of the robbed floor being driven, unquote, anywhere. But again, the question here isn't whether Strang and Buting could have presented James's experiments and opinions or what those experiments would show. The question is whether Avery sufficiently pled that it was objectively unreasonable for them not to do so, and that he was prejudiced as a result. Strickland, Valiet. An explanation why, or even an allegation that it was unreasonable for them not to do so, is absent from Avery's motion. Nor did Avery explain how he could possibly be prejudiced by his attorney's failure to hire an expert that did not rule out anything relevant about the state's case. And Avery has failed to argue on appeal that his motion was sufficient, or even that it was objectively unreasonable for Strang and Buting not to hire James. He again merely attacks the evidence submitted at trial. Whether current post-conviction counsel can attack the trial evidence is not the issue on appeal. Avery makes much of Strang's affidavit stating that he should have hired a blood splatter, ballistics, or trace evidence expert. But what Strang thinks now is irrelevant, quote, after an adverse verdict at trial, even the most experienced counsel may find it difficult to resist asking whether a different strategy might have been better, and, in the course of that reflection, to magnify their own responsibility for an unfavorable outcome, unquote. Richter, quote, Strickland, however, calls for an inquiry into the objective unreasonableness of counsel's performance, not counsel's subjective state of mind, unquote. At any rate, Avery did not provide this affidavit to the circuit court until his motion for reconsideration, and therefore it has no bearing on whether the circuit court properly denied the claims raised in Avery's June 2017 motion. Avery's claim that Strang and Buting were ineffective for failing to hire Symes was, and is, particularly insufficient. They did hire and present a forensic anthropologist who specialized in burned remains, Dr. Scott Fairgrieve. So, Avery's claim really is they were ineffective for failing to hire this particular expert, Symes. But an attorney is not efficient for hiring one qualified expert over another. See Hinton v. Alabama. Ineffective assistance, quote, does not consist of the hiring of an expert who, though qualified, was not qualified enough. The selection of an expert witness is a paradigmatic example of the type of strategic choice that, when made after thorough investigation of the law and facts, is virtually unchallengeable, unquote. Neither Avery's motion nor his brief saying anything about why, from Strang and Buting's perspective before trial, it was unreasonable for them to rely on Fairgrieve, who had testified for the prosecution in every case in his career until this one, and who refuted the state's forensic anthropologist, Dr. Leslie Eisenberg's conclusions.
Welcome to the Foul Play YouTube channel. This is Powder Puff Special Edition. And we just heard Suzanne reading first 40 pages of the state's response. So I can't thank you enough, Susan. That was absolutely beautiful. I mean, just a great job. Amazing.
Thank you, Sammy.
You're welcome. You're so very welcome. I just so appreciate you're so very thorough and very articulate, and I just have to thank you. But I wanted to know right from the start, are they allowed to reorganize Avery's motions? I mean, I get what they were doing with that. Really, technically, are they allowed to do all of this? And we have Dr. Silkman with us. We have Glenn and Bibi and Jack. We have Hansel, Linda, and Lindsay. Maz, nothing but a stump. Of course, Susan, Tintin, Wizard, Dr. Silkman. But that's a very basic question I have. Most of the stuff that comes out of my mouth will be layman's terms, okay? So bear with me. And forgive me if it gets a little humorous because I'm pretty sure people that understand all this legal mumbo jumbo will laugh at me, but I don't care. I'm still going to say it. So anybody have anything to say about that?
I'm going to jump.
I don't know the answer to it. Sorry.
I'm sorry, Susan. I don't either. The rearranging of facts and details we've seen in the past with these other briefs that they've written, especially, well, I'm not going to say especially, but if you recall, they did this with, I'm pretty sure with another brief where they did some rearranging, especially with Brendan. They really went around the bend to change the series of events to make it work for them. Now,
That's what they're doing here.
Absolutely. Now hearing this twice now with Susan reading it earlier, I will say that from a procedural standpoint, there may be something there. I don't know, but my real problem with it, because they keep going back to this procedural errors that Zoner has made. If there was such a procedural error, then why have we been at this now over 4 years now? And they've been replying to her. They've been engaging with her. If procedurally she can't do it, I haven't seen it because we've had all these other briefs and replies and all this other stuff that they've done. So number one, there's that. I'm going to stop now and let other people talk.
Oh, I got something to say. Exactly. They really should. They should have brought this up, I feel, in his first briefs. This was stuff that was there. And if you want to, keep on talking about procedure 24 times, let's be honest about it, it's too much. These are things that are way back when, and they're just trying to cast, trying to twist it around and make it look like he completely did, is off the wall. And not giving any merit to what KZ says.
No, they're completely disregarding, basically by doing this, disregarding her in every way, in my opinion.
Yeah, like she's dumb or something, like she ain't got no merits at all. I mean, come on, really, seriously, you want justice? Take a look at this.
And okay, 2007 preservation order. Can somebody explain that? I wrote down number 4 about the CD that defense received, and who received that CD and when.
Okay, I can answer a few of those. The preservation order was written by Willis, and that was in talking about the blood evidence. That has nothing to do with the bones and all this other stuff. And to me, it's a manipulation for them to try to lump that in with that particular order about the blood, because even then, Wisconsin, these other states too, but they knew, as science progressed, that better testing could, be found. So that part of it is separate than the actual statute of not destroying biological evidence. No, with the bones in 2011. Now, the other thing about the CD, I'll give you the series of events as I know them, and I actually, surprisingly, I just wrote this and I read it reply the other day, actually yesterday. Series of events with the Bailey CD. Am I still here?
Yep.
Yes, I hear
Okay,
you.
sorry.
Yeah.
Okay, so the Bailey CD. That happened. They took that computer, and Bailey did his forensic computer forensic thing to it, and this CD got created. Along about May 11th, 2006, that CD was turned over to Fassbender and a 2,400-page report. So they held onto this thing for 7 months. December of 2006, there was a major discovery dump. I'm going to say hundreds of items without looking, but it was a lot. It was the largest discovery dump of the entire case. So Kratz calls Fassbender to take all this stuff to String and Buting, which he does, minus the CD, the Bailey CD, and the report. Now, my personal feeling is he already had that CD and that report at some point. For whatever, those two items were included in that discovery material. They should have gotten it, but they didn't. Okay, move forward. Avery's trials in February. Brendan's trials right after that. Brendan's verdict is read in, I think, April 27th of 2007. That CD was given to Wiegert at some point and entered into evidence in the ledgers in June of 2007. So, 2 months after trial was over. That's the CD. Then,
Jack,
go ahead.
Sorry.
No, go ahead.
Are you saying that was listed in the discovery that they turned over
Absolutely.
to the defense? The Bailey CD was listed in there?
Absolutely.
In the report?
Absolutely.
Okay.
Both of those items were to be delivered to String and Buting. Now, this all got kind of gummed up. If you go back and read Judge Angie's one of her reply, I think she really screwed it up about how it's listed. She really messed it up because there are other CDs and DVDs and all that kind of thing that are also listed. But nonetheless, yes, they were supposed to get this material. And it took, obviously it took an act of Congress before she finally got it in 2018. And she got that copy, if I'm remembering correctly, somebody correct me if I'm wrong, that was a DOJ envelope that she got because she shared a photo of it in her brief. Anyway, that's those two answered. I'm going to shut up now.
Okay. Does anybody else have a question about those? Okay. Well, number 5, the state failed to notify Avery returning of the bones. Or are the bones not exculpatory? Which means favorable to the defendant that exonerates him or her of guilt. So we have new testing and everything now. So would that not be considered something that could potentially be exculpatory? It's biological. I mean, am I wrong?
If I could just quickly comment.
Yes.
What disturbs me, now I'm definitely not a lawyer and I definitely didn't understand all the legal mumbo jumbo. But essentially, from my perspective, what they did, guys, is first of all, mock Kathleen Zellner. They mocked Stephen Avery, and they had no respect at all for any of the experts, and that Kathleen had hired. And the point being made was, during Stephen's original trial, he hired one particular expert. Well, that should have been good enough, and you can't blame the state, etc., etc. But in regards to the bones, this was very, very devious, a very, very devious trick, just like with item FL. So essentially, because the officers that picked up the bones and packaged them and gave them back to the Horbach family, because they weren't forensic anthropologists or bone experts, the state can say, well, they didn't really know what they were picking out, so therefore we can say they didn't give back human bones, right? So that was their excuse, that it legitimized the fact that the state gave back bones, right? So in effect, it's not really to the state, it's not exculpatory forensic evidence, because the guys that picked the bones, they didn't know what they were doing. No one actually said they're definitively human, etc., etc., except one thing, right? If you have a look at Eisenberg's own report, right, she distinctively lists many of the bones in the Manitowoc County gravel pit as burnt, cut human bones, right? And of course, there are many other bones that were in that box that were obviously human. So there's no question in that sampling and mixture of cremains, there were human cremains, no question. What Eisenberg failed to do is that when she examined all the bones, as in the burn pit, Yonder Burn Barrel number 2, and the Manitowoc County gravel pit, she didn't say, right, here are the bones from all 3 regions. These are the bones that I've identified as human, and that's it. You had basically what you had was a big mishmash, and so you've got no proper, what can I say, documentation of those cremains. Now, what on earth are law enforcement officers going to forensic evidence, i.e., cremains, picking out bones and then saying, give these back to the Horbach family? It really, it completely boggles the mind.
Well, in
So,
this document, this is
yeah.
what I have a problem with. Acknowledge that the preservation order was violated. But, and then they say, although, skip right over it, as if it is irrelevant.
Well, it's quite clear from my perspective that the state did not want to give those bones or cremains to anyone else, right? Because there was that potential for further scientific testing, which potentially could have determined whose cremains they actually belonged to. So Ken Kratz and the state, whatever, they go back right to when those bones were examined by the FBI, right? And also Eisenberg, and I think also, yeah, Eisenberg and Dr. Fairgrieve. And they use the argument, well, if the FBI couldn't work out whose bones they were, if Eisenberg and Fairgrieve, who agreed with Eisenberg, couldn't work out what those bones were, then who else was going to? So, in effect, they didn't care about future scientific testing. They just used what they had, they packaged it all up and said, right, we've got to get rid of these cremains, because there was always the potential of new scientific testing that was going to be done. And it's very disrespectful. I can't remember which response it was in, but the state argued that the new machine, the Andy Rapid DNA machine, was not fit for purpose to identify the origin of those cremains, because it wasn't constructed for that purpose. So even where there was new technology, the state was actually trying to prevent Kathleen Zellner's experts from even attempting.
That right
So,
there, that is right there grounds
Yeah.
for some more shit. Excuse my
Well,
French.
well, ironically, what was that? It was 2011 when they gave the bones back, right?
correct.
So in 2010, this rapid DNA, anti-rapid DNA was really catching on, and the FBI was looking at it to maybe start using it. And that was
Correct.
in 2010. And then flash forward a year, bink, and they're hurrying up and giving the bones back.
Yeah.
Yes. But basically, what they wanted, please correct me if I'm wrong, they actually wanted legislative law to state that the anti-rapid DNA system could be used for forensic analysis, right?
Yeah, the
Now,
FBI, yeah, they were
yeah,
looking
yeah,
at it to start using it. Yes.
correct. So that way they were trying to block Kathleen Zellner's expert, the guy that actually invented the machine, from testing the bones. They're trying to prevent that.
Wow. I mean, this for me is a really big major issue. First of all, they acknowledge that the preservation order is violated via the fact that they did not inform Avery or his lawyers. And that's a really big deal. That is a big deal. So, that's a big thorn in my side in this so far, this response. And I'm sorry, but it's not a waste of judicial resources to exercise his rights. This appears yet again to be a denial to a fair trial or hearing.
One of the
Yes.
things that, and
That's what they're good at.
one of the things that really bothers me as well is who instigated the transfer. That's important. And anybody that thinks it's not, it's really important. Who picked up the phone and said, "Hey, about these cremains?" It's all of a sudden out of the blue. Where did this originate?
Fallon, wasn't it?
We don't know.
Oh,
Well,
well, that's a good question. We need to dig
Like a
into.
burning question.
Yep.
Which subnorm are they leaning on? Some of them, maybe I'm wrong. I didn't notice certain years indicated in each case they cite. And they acknowledge that they're understanding that when a prisoner files a motion or claim, they refer to it as an attack, as attacks.
Okay.
Now,
Yeah.
that's wrong. They claim,
I
and
you're
they
supposed
also
to be able to do that.
acknowledge most of them lack knowledge of the laws and terms within the laws, and or have low IQs. It is not sufficient reason for him to be entitled to an evidentiary hearing. Are you kidding me?
Do you hear all that language you just used right there? Entitled, low IQ,
Yeah.
not
Okay.
knowledgeable of the law.
Aren't you supposed to be
Acknowledge and then flip it.
It's
I just
maddening.
wanted to quickly add that I found, or I'm finding the language incredibly insulting and condescending.
Yes.
Practically every word and sentence is how I feel about that so far. All the other legal stuff aside.
About page 12 and 13. And they go on to, indicate they want to talk about this lack of him having access to counsel. Well, there's calls when he was first arrested, which indicate, so maybe they're dispatch, but indicate he was denied access to his lawyer, and the lawyer denied that he even was there. How is that not relevant? And he was violated. His rights were violated right from the start, just with that. And they're saying, but that's irrelevant. There's no proof for that.
I mean, Sammy, I mean, to me, and I think somebody made the comment, this was definitely meant to insult Kathleen Zellner and treat her like a rookie, as if this was her first dance in the legal profession, presenting a document like this, and there was no respect. It was a vicious attack on both Stephen himself, Kathleen Zellner, and also all her hired experts. Essentially, what they did is they ignored everything. And if you have a look at, I think it's page like 6, they basically said, well, this particular court, I forgot the exact words, but we're not charged here to look at these particular items, therefore we're going to ignore them. So they just basically drew a line under everything Kathleen Zellner presented and said, no, this isn't for us. Stephen Avery's guilt is nothing to do with us. This was determined in a court of law years ago, and that's not our concern.
Sorry about your luck.
Yeah, there was no respect, nothing. And if I could just add quickly, guys, it was actually Fallon and Garn who went through the bones, and they used, now wait for it, they also used Dr. Leslie Eisenberg's report. So therefore, they went through all the bones and they took out the bones which were human. Now, this is going to blow your mind, right? Remember the human pelvic bone that was at the Manitowoc County gravel pit, the one that Eisenberg said suspect possible human?
Yeah, correct.
Yeah, well, the guys actually went through Property Ledger 8675, and it says, I quote, the human bones were separated from the rest of the contents and photographed. So therefore, that debris pile that everyone's arguing about actually did contain human bones. So it made a complete mockery of everything, right? So in other words, the Manitowoc County gravel pit did contain cut human bones. And Dr. Eisenberg said, we have one victim, right? So therefore, their own documents contradict what they just said in that brief. And it's just truly the goal and overtness of these people is that they show no respect nor care factor.
Yeah, like that's that's enough right there, isn't it, for an evidentiary hearing? They're breaking, you know what I mean? That it just seems total madness to me that they would not see that and want to seek justice for that. I just, it's like they think she's playing a game of ping pong or something. I don't get it.
I think,
this
I might
document,
pipe in here.
go ahead. I want to hear it.
Okay. Gets me is that I think sometime in 2010, when I sort of sat around a conference, decided, well, what's going to be our next move? Now, by this time, Steve had been convicted for 3 years and was kind of working his way through the appeals process. 2011, decided to give the bones back on Fassbender or Uyghur and all the rest of them. Now, these prosecutors, they go into court during trial, they will bend over backwards to portray witnesses, barefaced liars. Are you a liar? Are you telling the truth? Blah, blah, blah. And then they'll call that witness on a lie that they've told in the past. They will discredit all of the evidence that witness has done. based on a lie years before. Now, what really bugs me about this, that the same prosecutors go into court and say, actually, yeah, we did give the bones back. It's a lie to defence counsel as part of 7 years. That's all right, you know, we can do that. But why is it defence can do that, or the prosecution are allowed to do that, and yet the defence are caught out in a lie? They're casted virtually nailed to a cross.
Yeah.
Makes sense.
Yeah. Well, they're known for this behavior. I mean, that's all I see in this.
It's all lies. It's all
Yes.
they are grasping at they are grasping at straws they've tried before, and because they've stood up under look at this kind of
Now you're cutting out.
I think they can do it again.
Well, somewhere after all of that, they acknowledge the courts were wrong, but blah, 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 and proceed to their very next thing they want to bring up. And really, they acknowledge things in here and then turn right around and skip right over it. It's really annoying. It's really bothersome. And it feels like they should be held accountable for this. Now, being is this is all they want to say about it. They've acknowledged it in my book.
Yeah, but the thing is, Sammy, you're correct. The thing is, Sammy, if you have a look at the some of the scenarios that they come up with in the report, they're false scenarios. It's a false argument,
Yep.
right? And so that they have this false argument, and then they argue against it, and it's something that Stephen Avery never claimed. Like when I was doing the report for Ida Mafel, since when did Stephen Avery claim that Teresa Horbach's death wasn't the result of 2 gunshot wounds to the head? Right? So these guys are making up scenarios, false scenarios, and then arguing against them, and furthermore rejecting everything that Stephen and his experts have put forward. And it is, I think, as Wizard said, it's a ping pong match. Okay, we've got this. We're going to say all these things. Now you spend the next 6 months arguing it. And to me, it really is quite shameful. Really is very shameful.
Feels like
Absolutely.
another big manipulation to me. I took that from it, and because not only everything else has been talked about, how many things did they not address that are really important? Number one, and I just popped in my head a minute ago, the Williams call. It wasn't addressed at all, and that was a major. To me, that's a big problem. A big problem. I mean, this guy.
Yeah.
I mean, this guy calls and he's supposed to be calling Fallon, but instead he calls Zellner and leaves this message about checking the bag. I mean, what? But they don't address
exactly.
they don't address it at all. They also talk. They
Yeah.
talk about a number of things. The key, they just completely blow it away. They just ignore it, like it doesn't matter.
Like her experts are absolutely nothing. And to me, it was a great big slap in the face. It was
Yep.
a slap in her face. It was a real dig into Stephen Avery and a spit on all of her experts. That's how I feel about it.
I feel it was
yes,
Josh
correct.
Call. I feel it was Josh Call protecting his mommy Peg's legacy.
Yes, I agree. When you have the world's very best, and these guys, if you have a look at their CVs, it pales in comparison to whatever the state produced. These guys are the best of the best.
Oh,
And
the
to
very best.
and to whitewash them and to ignore them, this report was a rubber stamp for what the circuit court said. And so if you look at it very carefully, they don't want to grant Stephen an evidentiary hearing on any grounds. Nothing.
Absolutely. As for
Totally agree.
as for adverse effect on his case and its ruling for conviction, the lawyer has admitted to ineffectual counsel.
Yeah, they admit to not doing what they could have done or should have done, and they are ignoring that too. Like I said, they ain't going nothing about merit. What is
Well,
real
no,
here?
they can't. I get that.
Yeah,
But this response so far is equivalent to me to trying to argue with someone who is only capable of throwing up Bible verses or quoting legal
I feel sure.
statutes rather than having a single thought of their own to validate their, their education in this. Repeating verses for every question or point as a response. That's all I can see here.
It was a rubber
Dodgeball.
stamping.
Yeah.
Yep, like dodgeball, and now they're back to ping pong. Like I said, it's just a game. They don't see any.
Well, you're
they're
right.
not seeking justice.
Yep. And as far as Redaunt's conversation, can anyone refresh my memory? Was this about the RAV4?
It was Fassbender. Correct.
Who
It was Fassbender.
DOJ said it was driven back onto Avery property?
Yeah.
Because this
It was
actually
Fassbender.
fits in with something that actually happened on Cuss Road. It has
Correct.
to.
In actual fact, Fassbender told Redaunt exactly how the RAV4 came into the property, but furthermore, we've got it on tape. Fassbender said the same thing to Stephen Avery on the November the 9th interrogation. So it's on tape. And to believe that now the state is saying it's mere hearsay is, to me, that's so disingenuous that it actually hurts. Especially when Tom Fassbender told, and Wiegert told Stephen Avery precisely how the Toyota RAV4 went onto the property. And they even mentioned the dog tracks, right? So everything fitted well. And, the thing that got me was about the flyover video being edited, and them saying, well, where's the proof that it's been edited? They were up in the air for about 4 or 5 hours.
You're minus about 4 or 5 hours.
It's really good.
Not to mention that when you go to the trouble of getting up into the air to do something like that, you don't just stay there for 3 freaking minutes. You know what I mean? Like,
yes.
no, God.
Yes.
It also goes, doesn't it go
Yes.
from plane to helicopter back to plane?
Yes, it does. Correct.
Yeah.
It actually changes a vehicle that's flying around. And,
right. Boy, they could take classes from me.
They passed the baton in air. Here you go.
Yes. So, the factor is they actually had Drum, the pilot, on the stand, and he said we went absolutely everywhere. We went Green Bay, we went all over the possible routes. Now, you trying to tell me that whoever was doing the photography said, don't worry, guys, I've only got 3 minutes of film in the camera and I'll just take some random shots? Right? I mean, this is what they're trying to argue.
Really did. Their all their photographs are messed up anyway. I mean, come on. Jeez.
That is correct.
Yeah. What
correct.
photograph? Yeah.
Yeah, that's correct.
Photograph the bones where they laid. Let's do that. How about their graph and doing the right thing to do with the bones? And now they won't see that they were spread about and that there was real human bones in the quarry. And I mean, come on, they're ignoring that completely. That is just that's all kinds of wrong.
Yes, it is.
Yes, it is. It is absolutely. I mean, you think from a family perspective, you could imagine the investigators knock on your door. They probably had like an urn or whatever like that to say. They organised it with the Hallbark family. And you could imagine the person saying, Mr. and Mrs. Hallbark, we don't know what we have here. It could be animal bones. It could be bones from a chicken. We don't know, but please accept this and
Not a
don't say
chance.
anything.
No way.
No
Right?
way in
There-
hell.
Of
No
course,
family would
the
want
human
that.
bones.
No.
Of course, the human bones.
Gosh.
Well, while we're having a little chuckle, can I ask, are the courts allowed to use this? Is it a legitimate legal term in a nutshell? Or can everything thereafter be, I'm asking, is that in a nutshell, a legitimate legal term? And if not, can everything thereafter be stricken from the response or Monday morning quarterbacking? I mean, come on.
Tammy,
Which
I don't,
means passing judgment after the fact. It's just like, okay,
Well,
they want to go into detail to explain this, the mere fact that Avery lacks the legal knowledge to address these things himself, which is why he has a legal representative, right?
Yeah, exactly. But well, what Tracy said was that they have legal basis for this. But come on. He wasn't able to get certain things and he wasn't able to do certain things. So they should also be looking at that if they really want justice.
Well, I
Well,
think the dispatch calls in and of itself from the very, very first day when he was incarcerated for this is proof in and of itself that they would go to any extreme length that they had to go to try to block him, basically.
well, sure. Yeah, I mean, when he was a pro se litigant, I mean, he did it himself. I mean, you know how limited he had to be. I mean, and we covered, I covered some of this stuff with Linda and what I heard lives about some of the stuff that he did on his own that Avery did. And this is about the investigation where he said he was being surveilled. Yeah, in a reality, in reality, I mean, considering his, his IQ and probably what he had available, he actually did pretty good. I mean, as far as his writing, I'm sure he probably had some help still.
Well,
Considering the IQ level, yes, he did.
he wasn't allowed to have all of his files or his anything at one time because it was so large that he had to get boxed at a time. He was limited
That's
to
right.
what he could even read. So
biggest-
they're limiting him on getting everything he needs to at one time to even make sense. And then you're saying he's not smart enough. Well, I think that's double down there on lack of understanding and
Right.
justice. It's like having no lawyer at all, being in court the first time.
And
But I find-
noticed that a lot of the case decisions that they cited are for the pro se are ridiculous.
Procedure.
Uh-huh.
But stuff that's gone down in the past, from the cases they're citing and what the court has ruled regarding pro se defendants, it's unbelievable.
It
It
is.
is absolutely egregious to me.
Yeah.
That they would put him in the jail going, oh, well, he has access to a phone at any given time. And yet they are intercepting calls that are being asked, is he there? They're going, nope, don't know who you're talking about, basically, is what's being said. And the lawyer's looking for him.
Oh,
People
yeah. November 9th.
need
that
Oh,
was
yeah.
horrific.
Terrible.
because it's a fact. It happened.
That was horrific. That I'm going to say a whole lot here on this today, but that was one of the horrific things that just made me kind of sick to my stomach when I found out that they had done that, withheld his legal counsel from him.
Violated his right.
All afternoon.
That should have, yeah, that should have been just the first. Oh God, no, that couldn't have been the first, but that should have just been a major thing. And the fact that was done should have been the very first constitutional right that was violated. That should have,
When
at
they
the very
question
least,
his claim to having his rights violated is totally invalid. That's wrong. That is so very wrong. It is in the dispatch calls, and people, you need to check it out because it happened. It's totally, completely the very first, most egregious thing that I experienced when going into this and exploring everything that I could possibly explore about this case. It was a major violation of his rights.
The whole thing they're doing with this answer is trying to get by on a technicality, procedurally barred.
Mm-hmm. Avery knowingly forfeits nothing in this. They continue to say throughout this document things like that this is forfeited and that is forfeited, basically because it wasn't addressed the very first go round when he had ineffectual counsel.
But Sammy, from hearing, and Susan, that you did a magnificent job. I don't know how you got through it, but the what was I going to say? They expected Stephen Avery to be Nostradamus and foresee future events, which is truly remarkable. And the mere fact that they rejected, procedurally barred Stephen, it meant that no matter what Kathleen Zorner presented, and no matter how eloquent the research was, and you notice how they kept on mocking her by saying experiments in quotations as though they were done like a high school standard. I don't think they took much credence in anything that was done. The one apart from the bones, the one thing that shocked me the most was item FL. I know that comes on later on in the readings, but what they did with that goes to prove that they can prove that there were really 9 commandments or 11 commandments, and that Moses got it wrong by using technicalities, by doing everything by nitpicking. They can come up with any scenario that they want, and the way they dispelled item FL like a hot potato goes to show that if they have no respect for that, then they've got no respect for anything, right?
Absolutely.
To me, what I want to know, guys, is what is Kathleen Zorner going to do now?
It'll be interesting to see how she replies. I will say that I think she'll come out swinging personally. That's just me, though.
I think so
Well,
too. I
first
don't
of
think she's
all,
going to take those insults just laying down and just when she comes back, it's going to be less professional. Not that she's going to be professional, but less. She's going to be a little more scathing than I think she has been in prior motions.
make no mistake about it, this lady is not new to this game. In my opinion, all evidence warrants discussion, and lack thereof, as much of it is, if not all of it, is faux or foul, and we know this.
Yeah, I think the time to show professional courtesy, and that's exactly what Kathleen Zorner has done. If you read all her filings, they're just magnificently put together, shows a high degree of respect, professionalism. This, to me, is just simply high school bully boy tactics by the state, basically laughing in the face of Stephen, Kathleen Zorner, and all her professionals that she hired. I think Kathleen Zorner has to really hit below the belt now. She's got to really drive the message home, because this could well be the last bastion that Stephen has before he's got no hope at all.
Well, there's plenty of proof in this for ineffectual counsel, and they want to ignore that. They want to ignore it, saying, well, prove it. Give me an example. When, because they're saying on page 30, Avery failed to explain claims as to impeachment of certain individuals due to ineffectual counsel. There is his proof in and of itself of ineffectual counsel. because they failed to hire experts. It equals ineffectual counsel to me.
At the beginning, at the very least. I wanted to kind of go back really quickly to the you were talking, Sammy, about the language that they were using, that was being used in the response, and you I think you were asking, is that legal to use some of that terminology? And I can't speak to whether it's legal or not. I mean, I don't know if that's subjective or not, but at the very least, when I'm hearing some of those words, like you said, nutshell, and all the little air quotes that I
Monday
was
morning
imagining, and
quarterbacking.
things
Yeah,
like,
Monday morning quarterbacking.
I just thought, you know what? You are supposed to be a professional filing this professional document. You sound like you're saying it like just like any of us, for example,
That's
just
them
sitting
being
back
smart ass. That's
and
what it really is.
and that is whether the language is legal or not, it's the utter lack from word one to the very end, most likely of professional. There's just zero professionalism, and that just takes so much credibility from the fact that they're even trying to be somewhat intelligently responding to this, because
Really
they're
good at citing cases, but they're not paying any attention
exactly,
to
and
this
that's what I feel like they're basing it on. That's what they're hiding behind, is citing other cases. So
So, okay, let me ask a question, because I guess somewhere along the line I wasn't really paying attention when Zeldner asked to expand her words. She was denied. Who does that? Her opponent? Who denies her that?
The court.
Okay. So when you're allowed to limit your opponent count, it allows room for one to say all the arguments are insufficient and therefore forfeited. Lack of permission to allow a motion to expand the limits of words has in fact left no room for proper and accurate explanations and or examples, and or leaves no room to do so.
Well,
I mean, come on.
that comes into some of the stuff
It's
they were
another
talking about.
strategy.
Yeah, that goes back to some of the things they were talking about, that it wasn't explained. But there's a limitation on how much she can put in a brief. She's limited, right?
They were allowed to expand theirs.
Well, she was allowed to expand hers once. I know, I can't remember which one it was, but that goes back again to, let's just say, the is it Dr. Palahniuk, Dr. Silkman that did the bullet. He wasn't.
Yes.
He wasn't allowed to go any further than to say it's not bone, it's wood and paint. It's not.
Yeah.
So but he could do anything else to it.
Correct. And remember, he would only have a limited amount of time to access item FL. And if you remember, a representative of the state was right next to him at all times, right? So he was under supervision. So someone from the state came down with item FL and stood right next to Palahniuk and Zellner when they were observing the bullet. And what Palahniuk said was, hey, look, this is what I found, right? If you want me to further identify what these other components are, I need access to the bullet. I need to prise them off the bullet, which means that what you're doing is you're now going to alter the evidence, because you're taking out bits and pieces and you're doing further analysis. That's all he requested, right? But his findings were rock solid. Item FL didn't have bone. And the mere fact of that now, the state is saying, well, he never said what other things were present or absent, right? So in other words, what was the state expecting? A complete, thorough analysis of every element present or absent? It's ludicrous. The critical finding there, guys, is that item FL did not have bone. And he proved that chemically, right? Using a particular microscope. No. The state were not happy with that. They wanted to find out all other bits and pieces that were missing or present. but they forgot that the most important aspect of his findings was the absence of bone in item FL. So, in effect, what they did was, okay, his report's incomplete, we're rejecting it.
Well, it's
That's the way they thought.
equivalent to you are trying to find out the truth amongst your children, teenagers or something, what occurred, and you want to hear their side of the story. You tell them, but you get to tell me in 2 sentences. That's what this is
Yes.
equating to.
Correct. To me, it blows my mind, but I shouldn't be none of us here should be surprised by the tactics used. And can I just Sammy, just sorry, if I can make just a final comment, because I have to leave. I've got something that I've got to do.
Absolutely.
It's almost, I know you guys are gonna hit me over the head for this. It's almost though Kathleen Zellner had to sit with someone from Wisconsin, like a felon, hire him and sit down with him and say, right, what do I need to do to write a successful application that the court is going to A, pay due respect, and B, accept? It's almost as though they nitpick everything that Zellner said.
He's a bulldog, and he knows Wisconsin law backwards and forwards, and you're not wrong.
Yes, he does.
You're not wrong.
Yes, he does.
Right.
And the reason why I say that, guys, is because during I think it was 2010 post-conviction hearings of Brendan Dassey, well, guess who was defending Len Kaczynski and Michael O'Kelly and objecting? Tom Fallon. Now, how in the hell was someone who prosecuted Brendan was now standing up for Kaczynski and O'Kelly and telling the judge, I object, Your Honor. They can't ask those types of questions. So that's what I'm trying to allude to. You have to get down and dirty with the opposition and find out, okay, what do I need to do to write a successful filing? That's my final comment.
Thank you, Dr. Silkman. I do appreciate your time. I hope I haven't wasted
No, not
your
at
time.
all.
I
Not
just
at all.
have a lot of stuff. The first 40 pages of this response has me seething.
Yes.
I'm trying to do it gracefully.
Doing a good job, guys. Take care, everyone.
Thank you so much.
Thank you, Doctor.
Thank you, Dr. Silkman.
Have a good day.
Good night, Doctor.
Oh, I do want to tell the listeners that that you can come visit us on Discord and have further discussions. Better yet, I would love for you to leave a comment after this video in the comments section and put your questions there. Raise some points here. I don't care what they are, and we'll try to address them the best that we can. Look into if there's something that's been asked about this first 40 pages that we haven't brought up, go ahead, put your question down there because we sure need them. What else does anyone have to say, or what would you like to say?
I just want to talk about the forest of paperwork that he filed. Again, back to language. I just thought that was the first word that caught me as the most insulting, arrogant, unprofessional thing. Forest of paperwork, or how it was worded. That's all I want to say about that.
I just see it, the first 40 pages, really reading into it now. I just hope that the Court of Appeals, not getting anywhere near to the rest of the document, but this just feels like they're trying to manipulate these judges and saying, we had a trial, we've had all this stuff. Just ignore all this other stuff that Zellner's done. It don't matter. Procedurally, she can't do it. That's what it feels like to me. And trying to hoodwink them into an agreeing to it. So we'll see.
Mm-hmm. I hope not. I hope they're smarter than that.
I do too.
Well, if no one else has anything else to say, then I'm going to tell you that I want you all to, I did not prepare the feel good moment. I feel like right now, the fact that any one of us is still on the face of the earth and we're safe, we're okay, is really important right now. We need to stick together as humanity, stand up for each other in a good, positive, peaceful manner. So much going on. We need to be caring about each other and not ripping up our communities. So I want you to look at everyone in your neighborhood, everyone in your family, and just need to look at yourself, at humanity and how important humanity is, and how all this destruction, these communities that are going on all over the country, it's not helping us at all. And it's not helping the cause. But I want to tell everyone that take a look at this and don't count the days. Make the days count. Make the days count. This is a very important phrase, and I say it all the time, but I really mean it. Say what I mean, and I mean what I say. So after saying that, I want to tell you I love you all. Thank you so much for listening. This has been a Foul Play production.